How does a prosecutor decide which cases they're going to dismiss or reduce? It's probably not the reasons why you think they do. If you're interested in the state of the law, stay tuned. This is the video for you. My name is Attorney Lance Freider. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. I'm putting out these videos to help educate the public. Now I'm just going to jump right into it. Why or how does a prosecutor decide to reduce or dismiss a case? Because that's what we want, right? If we're charged with a crime, we want that case dismissed, or if it's not realistic to have it dismissed, we want it reduced. And usually the prosecutor has the goods, right? They've got a professional witness. They might have lay witnesses also. There's an entire police report written up against you. You might be caught red-handed stealing something. You might have a breath test that's over the limit. A prosecutor generally can convict you if they want to. So what are the reasons why they may not want to? And I think the number one reason why prosecutors reduce or dismiss cases is because of their caseload. Their caseload is a big problem. Now, when we watch a trial on YouTube or some other, or Law and Order for watching a fictitious trial, right? We just see the parts that happen, right? We just say, hey, the trial was a few hours, no big deal. But in reality, it's a huge deal. It's a huge deal for the prosecutors, a huge deal for the court, huge deal for the defense. There's maybe dozens and sometimes hundreds and sometimes thousands of hours of preparation that goes into a trial. And guess what? A prosecutor's a human being. They have a family, right? They want to watch the Seahawks if you're around here, maybe, or maybe they don't. And they want to live their life. And spending all this time getting ready for that shoplifting case from Target doesn't really seem to be what they went to law school for. So the caseload, realizing they're carrying hundreds of cases, and they can maybe do 1 or 2 trials a trial term. And most courts have trial terms maybe once a month. Some have it twice a month. What are they going to do with all those other hundreds of cases? Well, they need to figure out what to do with them. So caseload is the main reason. So what do they go to number 2 when they try to decide, well, Lance, okay, they have a big caseload. How's that help me? Well, I think the second thing we need to look at is culture. The culture of that prosecutor's office. When people ask me, Lance, how is it you can defend people? How can you defend these terrible people? First of all, no one's terrible because they're charged with a crime. I reject that. That's ridiculous. There are exceptions, obviously. But what I look at is it's our job to get the best possible result that the culture of the prosecutor's office and the court will allow. Like what normally happens in a well-defended case in South District Court in Lynnwood on a theft charge versus what happens in a well-defended case on an assault charge in Redmond, right? And what do we know about the personalities of those prosecutors? So that prosecutor thinks, okay, what can I do to take care of my caseload because these can't all go to trial? So the culture of what they're allowed to do and what's normal for them will affect what cases they decide to reduce or dismiss and what vehicles they have available for that. If you've watched this station, some prosecutors have something called a stipulated order of continuance available. That's a great tool for a prosecutor to say, hey, I'm going to give you a chance to earn a dismissal, but I'm going to take an insurance policy on your behavior, right? If you stay out of trouble and are a good defendant, well, I'm more justified in dismissing your case. So I'm going to take out an insurance policy that protects me from a mistake because I don't want to be the one as a prosecutor in the news saying I let someone go and the next thing they're in the news, harming someone in a serious way. I always worried about that when I was a prosecutor. I remember I would be at the gym, I'd be on the elliptical, some little 25-year-old kid, and I'd see some news thing flash up there. Someone got hurt, someone got stabbed, something bad happened. I'd say, please don't let that be somebody I just let go, right? Because we don't want to make mistakes. So culture, I think, is the second reason that they can do those things. It's sort of what is normal in their court. And that's why if you call us, you call up a really bad court with a bad prosecutor, and I'll let you know, hey, this court's going to be a lot harder than this other court. And that's why we're so obsessed about who the law enforcement agency is, because who the law enforcement agency is that is conducting the charge and doing the stop and the arrest and the accusations will control what prosecutor makes the decisions. So if we move on to number 3, I think the third reason is client affirmatives, right? We haven't got to the one everyone's thinking yet, and I'm going to talk about that, the facts of the case, right? But it really is sort of last. The third one is client affirmatives. What has the client done? What has the defendant done to make the prosecutor understand that they're part of the solution, right? How are we going to practice restorative justice, at least on non-felonies, to try to help the defendant who got into some hot water, a case they might be able to prove? Maybe some alcohol and drug education or treatment is necessary. Maybe some psychological counseling is necessary, right? I'm all for personal counseling. Maybe it's some anger management or some domestic violence type treatment is necessary. There's lots of things that the client can do to improve themselves, to make the most out of the crisis, right? To then impress the prosecutor, hey, I'm a good risk. I should be given extra credit because of what I've done to respond to this negative that I'm accused of. And to a really good prosecutor, and there's a lot of them out there, that makes a big difference, right? Because we all know we're not solving anything by throwing someone in jail. Well, I'm going to put you in jail for a week because you did this. Well, who's taking care of the dog? Who's going to work? We're already hand to mouth. How many payday loans are we going to need now just to stay in our apartment because the prosecutor wanted 7 days in jail? Does that really change someone's behavior? Absolutely not. It does not. I got 30 years to say it doesn't. And so I think that's the third one. Number 4, the reason why they might do a reduction would be, or a dismissal, sometimes wishes of the victim. It sort of combines with all of that. It's not number 1. The victim in a case does not control the outcome, with rare exception. It's the state versus the defendant, not the victim versus the defendant. But certainly if the victim is saying, hey, I don't want this case to proceed, it makes it easier for that prosecutor to look at the earlier numbers, right, and decide, well, no one's going to complain if I get rid of this case or reduce it, and I'm going to have one less thing to do. And finally, number 5 is the weaknesses in their case, the facts of their case. The trouble is when you start with number 5 and arguing, you give up everything else that we can actually control, right? Because a prosecutor has very little executive function available to look and argue the facts of the case at a pretrial setting. They'll read about those old cases they got us get ready for trial for, right? Those dozens or hundreds of hours getting ready for trial. And so the facts of the case should be pointed out, but they're an aside and a combination to everything else. If your attorney's only focusing on the facts of the case, they're giving up a lot of opportunity to improve your chances for the outcome that you want. So these all add up, right? And just please wipe out of your mouth. Take soap and wipe out of your mouth. Well, they don't want to spend all this money on my case, or they have better things to do. And that's how we feel. It makes us feel better if we're accused. And that makes logical sense, but it's 100% inaccurate. All they have to do is prosecute you. That's their actual job. For years and years and years, that's all they do. They don't care what it costs, or they don't care about better things to do except regarding their caseload. What we want to focus on is those earlier steps. So then once we have all those earlier steps, we can also talk about that last one, the facts of the case, and try to have them all combined to make it very clear that it's your case that deserves the reduction, or your case that deserves the dismissal, not the next one that they're going to take to trial and try to put in jail. So that's my 2 cents from doing this for 30 years. I feel strongly about it, and I hope that gives you a better understanding of why prosecutors reduce or dismiss cases. I was one for the first 7 years of my career, so I know a little something about it. If you found this useful, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you got a criminal case in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.